Okay, so special counsel Jack Smith has just filed a blistering response to an incredibly vague motion that Trump's lawyers filed to compel discovery in the Mar-a-Lago classified documents espionage case. And it is truly remarkable and honestly a work of art. So, something Trump has done in other cases and is attempting to do here again is basically make the government come up with documents that don't even exist because his entire legal defense is that there is some grand conspiracy to get him. You saw that in both Washington, D.C. and Fulton County, where Trump's attorneys made requests for, quote, deleted January 6th materials. And the judge in that case, Judge McAfee, responded very simply, these don't exist. So in both of those cases, Trump also made requests for any materials and any communications from any agency in government that exonerates him. Now, the problem with all of that is, and in order to compel discovery, which is essentially saying to the other side, we want to see a certain set of documents and this is their relevance to our case, you have to be very specific. You can't just say, like Trump is here and like he's done before, give me everything that says I'm innocent. You need to be specific. You need to say something like, I have evidence that the Department of Justice sent text messages to the special counsel saying that they should prosecute me illegally and they were sent within a certain time frame, so we deserve to see a record of their correspondence between those dates. But obviously, Trump and apparently his lawyers too have no real understanding of the law other than how to skirt it, of course. So in the current classified documents case, Trump asked for any documents that tend to show that he's a victim of selective and vindictive prosecution. And there's a few legal issues with that, which the special counsel raises. And then Jack Smith really hones in and hammers Trump in his response, which I'm going to show you now because it's actually fairly straightforward and really easy to understand. So after Trump appointed Judge Eileen Cannon denied Trump's prior request to delay his espionage trial last week, Trump's legal team filed a bunch of motions to dismiss the case for a variety of flimsy reasons that likely will not hold up. But they also filed motions to compel evidence that Jack Smith, in his response, essentially just says are made up. So while in previous court filings, Jack Smith has said things like Trump's request for discovery put witnesses at risk, this one basically just says this is literally asking for something that does not exist. In the special counsel's response to Trump's motion to compel this discovery, he says, quote, as will be discussed in more depth in the government's forthcoming response to Trump's motion to dismiss, the defendants have not and cannot satisfy the requirements for discovery on a claim of either selective or vindictive prosecution. First, the defendant's attempt to obtain discovery based on selective prosecution fails at the initial step, which requires them to identify someone who, quote, was similarly situated with the defendant. None of the purported comparators the defendants identify is similarly situated. There have been many government officials who have possessed classified documents after the ends of their terms in office, often inadvertently, sometimes negligently, and very occasionally willfully. There have also been a very small number of cases in which former government officials who have been found in possession of classified documents have briefly resisted the government's lawful efforts to recover them. But there has never been a case in American history in which a former official has engaged in conduct remotely similar to Trump's. He intentionally took possession of a vast trove of some of the nation's most sensitive documents and stored them in unsecured locations at his heavily trafficked social club. When the National Archives and Records Administration, NARA, initially sought their return before learning that they contained classified national defense information, Trump delayed, obfuscated, and dissembled. Faced with the possibility of legal action, he ostensibly agreed to comply with NARA's request, but in fact engaged in additional deception, returning only a fraction of the documents in his possession while claiming that his production was complete. Then, when presented with the grand jury subpoena demanding the return of the remaining documents bearing classification markings, Trump attempted to enlist his own attorney in the corrupt endeavor, suggesting that he falsely tell the FBI and grand jury that Trump did not have any documents and suggesting that his attorney hide or destroy documents rather than produce them to the government. Failing in his effort to corrupt the attorney, Trump enlisted his trusted bodyman, co-defendant Waltine Nauta, in a scheme to deceive the attorney by moving boxes to conceal his continued possession of classified documents. As a result, Trump, through his attorney, again returned only a portion of the classified documents in his possession while falsely claiming that his production was complete. The obstructive conduct even persisted from there. In June 2022, knowing that he had arranged for Nauta to move boxes to conceal them from Trump's attorney, and knowing that the government had subpoenaed the security video footage that would reveal the surreptitious box movement, Trump, now joined by not only Nauta, but also co-defendant Carlos de Oliveira, attempted to have the information technology manager at Mar-a-Lago delete the video footage that would show the movement of boxes. So that's just the first prong of the response, where the special counsel explicitly says that no one has even come close to committing the type of conduct that the former president has. There are no, quote, similarly situated individuals as the former president, which is part of the showing that he needs to make for his vindictive prosecution claim. And why are there no similarly situated individuals? Well, look at what the president stole, and look at what he did to try and cover it up. Here's from Ben Meiselas. This is one of the highly classified documents Donald Trump stole involving, quote, nuclear weaponry of the United States and concealed at Mar-a-Lago. In his recently filed motion to dismiss before Judge Eileen Cannon, Trump claims that under the Presidential Records Act, this is his personal property. And you can see here on this document, it says undated document concerning nuclear weaponry of the United States. A similarly situated individual would basically be a former president who stole documents related to nuclear weapons. And then finding out the government wanted the documents back, said he's going to comply, but instead secretly enlists a bunch of his cronies to cover it up and not comply with the investigation. And that simply does not exist. So Trump's attorneys in their filings also try to claim that President Biden did the same thing as Trump here, which is laughable. And here was their response to that. The defendants have not identified anyone who has engaged in a remotely similar suite of willful and deceitful criminal conduct and not been prosecuted, nor could they. Indeed, the comparators on which they rely are readily distinguishable. For example, their primary comparator is Joseph R. Biden, whose conduct is described in the recently issued report by Special Counsel Robert K. Hur. But as the Hur report itself recognizes, quote, several material distinctions between Mr. Trump's case and Mr. Biden's are clear. Most notably, Trump, unlike Biden, is alleged to have engaged in extensive and repeated efforts to obstruct justice and thwart the return of documents bearing classification markings. And the evidence concerning the two men's intent, whether they knowingly possessed and willfully retained such documents, is also starkly different, as reflected in the Hur report's conclusion that, quote, the evidence falls short of establishing Mr. Biden's willful retention of the classified Afghanistan documents beyond a reasonable doubt. Unlike the evidence involving Mr. Biden, the allegations set forth in the indictment of Mr. Trump, if proven, would clearly establish not only Mr. Trump's willfulness, but also serious aggregating facts. The defendant's request for discovery on a selective prosecution theory can be denied on this basis alone. Separately, the evidence that defendants have presented falls woefully short of establishing either discriminatory intent for purposes of a selective prosecution claim or animus and causation for purposes of a vindictive prosecution claim. They contend that the incumbent president has secretly directed his prosecution using the special counsel as a, quote, puppet or stalking horse in order to retaliate against Trump for exercising his right to criticize him and run against him. But the sources on which they rely, even if taken at face value, undercut rather than support this conspiracy theory, as they repeatedly emphasize the prosecutorial decisions made by the Department of Justice generally and the special counsel specifically have been made on the basis of the facts and the law, not by political considerations. The defendants offer no evidence to the contrary because there is no such evidence. So Jack Smith quotes Trump's own appointee, the special counsel who vindicated President Biden, as to why Biden is not a similarly situated individual here. He was found innocent. This was not the same. Your own special counsel you appointed is the one who said so. So essentially, there are two big issues here. First, Trump is asking for information and documents that don't even exist. He can't just wave his hands and say, give me everything that says I'm right. But then, moreover, there are no similarly situated individuals to Trump, which is a showing he needs to make. There's no one in a position like him who has engaged in a crime spree, the likes of which he has. So this is something we are seeing time and time again, where Trump is just filing baseless motion after baseless motion. And it really just looks like he has lawyers who are simply just yes men, pretending the law doesn't exist and giving Trump what he wants. There's no respect for process and there's no respect for the law at all. They're basically just saying, I'm innocent. Send me the documents that prove I'm innocent. I mean, it's no wonder why most of Trump's lawyers have quit. They represent Trump how he wants to be represented, and then they end up putting their own legal careers at risk. Just look at Rudy Giuliani and Sidney Powell, who destroyed their legal careers over defending Trump. There are, in fact, rules that lawyers must follow, or they can lose their licenses or be sanctioned by attorney disciplinary bodies. Now, Judge Cannon has set a pretrial hearing in this case for May 14th, 2024, and a trial date for May 20th. We're going to keep you up to date on all the latest legal news coming out of both this case and all of Trump's other legal woes as they develop. So do us a huge favor, like this video, subscribe to our channel, and help us grow the new media ecosystem this country desperately needs. With Really American Media, I'm Justin Horwitz. Thanks.